Good evening, ladies and gentlemen. Very warm welcome to this current legal problems lecture. My name is Dr. Mark D'Souza. I am one of the editors of the current legal problems journal and lecture series, and my role this evening is purely ceremonial and as nominal as I can make it. My role is to introduce the chair for today's lecture by Dr. Bolanle Adebola. Her lecture will be on justice-driven insolvency law, a normative theory, and our chair for tonight's lecture, we're very privileged to have Lord Justice Zacaroli, who is the Justice of the Court of Appeal of England and Wales and the Tax and Chancery Chamber President. Lord Justice Zacaroli was called to the bar in 1987 and took silk in 2006. He specialized in insolvency, banking and commercial law and has been a member of the Management Committee of the Bar Pro Bono Unit since 2001, the Insolvency Rules Committee since 2012, and the Financial Markets Law Committee since 2015. He was appointed a High Court judge in the Chancery Division in 2017 and a Court of Appeal judge in 2024. It's a genuine honor to have you moderating this lecture and subsequent Q&A session. For the audience, a quick reminder of the format. Dr. Adebola will speak for approximately 40 minutes, followed by about 10 to 15 minutes of Q&A. I think the first question has been reserved for our chair. But we still know that 15 minutes is not a long time, and therefore we invite you, if you haven't had time to ask your question during the Q&A session, to catch Dr. Adebola outside immediately after the session, where there will be a drinks reception. So that's all from me. I'm going to hand over the floor to Lord Justice.
Thank you very much. Good evening, everyone. Professor Adebola will be known to most of you, I'm sure, but to those who aren't in the know, she's the Associate Professor of Law at the University of Reading, where she specialises in international commercial law. Her primary research, of which we're going to hear a lot more tonight, focuses on the development of justice-based corporate rescue systems using socio-legal, comparative and empirical approaches. She has made significant contributions to academic policy and reform debates in both developing and developed economies. Now, she holds many positions, but amongst those are she is the founder and convener of the Applied Commercial Law Research Hub. She's the first Vice President of the Restructuring and Insolvency Committee of the Nigerian Bar Association's section on business law, and she is an academic member of both Insol and the ILA. So without more ado, Professor Adebola.
Thank you very much, Lord Justice Zacaroli, for your kind introduction, and thank you also to everyone who is present in the room and to anyone who is online. And I'm very happy to see some faces here. My LLM tutor from Bangor has traveled all the way down. I can see Neil. I can see some of my students, my teachers, people who've taken care of me several years. My PGR director, my very first supervisor. I'm thrilled to see you all. Now, my first CLP lecture was around the start of my PhD. It was delivered, of course, in a room somewhere close by here. The structure of the building has changed, so I'm not sure where exactly it was then. But it was delivered by Dr. Sandra Frisbee on prepacks. And I remember sitting in the audience transfixed as she argued about the role and the utility of prepacks. Now, it was one of those formative moments because her framing triggered questions in me that I was as yet unable to express, but that moment stayed with me. And over time, I realized that I was grappling not with disagreement about one mechanism or about one lecture, but about a deeper problem. I was grappling with questions about the intellectual foundations of the field, the very question of what legitimizes insolvency law at all. I would like to thank Mark and thank the Current Legal Problems team for sustaining this remarkable platform over decades, and for the invitation, I think, finally to set out my response to that question. It's truly an honor, and I can only hope that my talk today, because I see some of my students in the audience as well, might, get some of them to seriously engage with insolvency theory in future. So that's a picture of me during my PhD, eating a carrot, and pondering the questions of insolvency law and life. You know, the response I offer today, I would say, emerged from a very personal journey. I've always been drawn, to foundational questions about meaning and justification. And of course, these inevitably tend towards philosophy. So a few years ago, as I was doing what I call a life MOT, I started to ask myself, why not combine the two things you like? So you combine philosophy with corporate and insolvency law, and that way, you bring your full authentic self into the field. As is well known, I've been fascinated by pre-packs, perhaps ever since that CLP lecture, I don't know. But the questions that puzzled me since that Frisbee lecture were, foundational questions. Why was it insufficient merely to look at the role and utility of pre-packs? Was the pre-pack legitimate? What makes insolvency law legitimate? What justifies its coercive authority? Now, these questions require understanding what insolvency law is, and for me, their answers, of course, lay in moral and political philosophy. Now, I was fortunate to obtain a University of Reading Research Fellowship, which gave me a year to focus exclusively on philosophy, a lot of it, and then to apply those lens to insolvency law. Now, I'm not the first to theorize the legitimacy of insolvency law. My paper itself engages with canonical theories of insolvency law, from Thomas Jackson, Douglas Byrd, Elizabeth Warren, J. Westbrook, Karen Gross. I'm also not the first to apply moral and political philosophy to insolvency law. We've had Donald Koropkin, Karen Gross, Ray Smokle. But what I present today is the result of my journey, my answers to the questions that will not let me go. And I hope that I can offer a different frame of how we think about insolvency law's foundations and its methodologies. So I'd like to give a quick overview of the paper because it's not been shared widely with people who've attended. I was saying that it's now in its sixth iteration, so no one has seen the sixth iteration of that paper. The paper itself consists of 6 main parts, including the introduction and the conclusion, but this is the beating heart of the paper. Section 2, as you can see, is the canonical theoretical debate. And here the paper will set out the dominant theories of insolvency law, which in reality are also 3 dominant approaches to insolvency law. And it will critically examine their common features and their distinct propositions. Now, the common thread across all is that insolvency law is a situation of cooperation, and this provides the starting point for my turn to philosophy. Now, sections 3 and 4, which are justice-driven insolvency law and ontological approach, justice-driven insolvency law and evaluative framework, set out my proposed theory, and they are rooted, set out my proposed theory of insolvency law. Now, my approach is shaped methodologically by Singer's approach to normative analysis, which grounds moral reasoning in pragmatic justification rather than idealized hypotheticals. So I'm not dealing with hypotheticals here. Now, my theory itself makes an ontological claim, a claim about what insolvency law is. And that claim is that insolvency is constitutive of justice. Section 5, which is the last bit here, which is reconceptualizing the field, it talks about how I reimagine the field, how I see the field going forward. It argues that all dominant theories of insolvency law are rooted in prior approaches to justice, which I then examine. And essentially, I argue that what we have been faced with have been competing justice propositions in insolvency law, which I then uncover and critique. And then I, of course, advance reasons why Judicial and its approach to justice are ideal for the stability and future development of insolvency law. So, if you're ready, let's begin. Right. So, given that there are non-experts in the room as well, I will set out the dominant theories. But what I'm really interested in setting out here is what I think their core similarities are, and then the distinct normative claims that they make, from which I make my points. So while much has been written about insolvency law for centuries, the very first theories, as we call them, emerged following the enactment of the U.S. bankruptcy law in 1978, which replaced the 1938 Act. And that law introduced the iconic Chapter 11, which has become the lodestar for corporate rescue or corporate reorganization procedures globally. Now, the very first theory was the creditors' bargain theory, which was proposed by Thomas Jackson and sustained by his collaborator Douglas Byrd and others. Now, their reasoning fits into the approach that in contemporary insolvency scholarship is known as the proceduralist approach. Now, what it does is that it engages with the economic analysis of law, and as you know, the economic analysis of law comes with its narrow functionalism. It asks, what the purpose of laws are. And what it does also is that it privileges efficiency and economic function over all other values and evaluations of insolvency law. Now, this is how the language of functionalism entered into insolvency law. Now, the theory claims that insolvency law is a universally accepted debt collection device that responds to a debtor's situation of multiple default. That's when the debtor is owing several people at the same time. And what it does is that it allows the contractual creditors of the company to coordinate their response. In so doing, it maximizes value in that failing or failed company. Now, its distinct normative claim, what it says that insolvency law ought to do, is that insolvency law is to maximize value for the debtor's contractual creditors only. Now, they insist that insolvency law is merely a coordination device. It has no additional powers, and so it must respect pre-insolvency entitlements and makes no redistribution in the name of, equality, equity, and whatever else you may call it. Now, other theories, including mine, effectively have been responding to these claims since. By the late 1980s, Elizabeth Warren, whom you might know from politics in the US these days, and her frequent collaborators challenged the narrow perspective of the creditors' bargain theory through a theory they described as the loss distribution theory. Now, they relied on empirical evidence about how the system worked in order to show what they considered the limitations of the creditors' bargain theory. But their use of data revealed the stories of real human complexity that are engaged in the realm of insolvency. Now, similar to the creditors' bargain theory, they argue that insolvency law responds to multiple defaults. Now, but what they show is that those losses are suffered by several stakeholders, not just the creditors as creditors, but they include the losses suffered by employees who would be owed, wages and owed various other entitlements that they have. But they would also consider the loss of their jobs as one of the losses that they would face. So unsecured creditors who might be suppliers will consider how much they have not been paid, but they would also consider the loss of a commercial, let's call it a viable commercial relationship as the losses that they faced. And so for them, they argued that the question that insolvency law has to answer is how the losses that are faced, these complex losses that are faced, would be distributed. And for that reason, they argued that insolvency law should make distribution choices based on the capacity to bear loss. Now, while loss distribution theory is sometimes described or classified as communitarian theory, they're not at their core the same. And I think I do take exception to their being conflated in that way. Communitarian theory differs both in its methodology as well as in its ontology, what it talks about or what it is. Now, communitarian theory was proposed in the 90s by Karen Gross, and Gross argued, in fact, that all the theories, such as the creditors bargain theory and loss distribution theory, that only thought about the creditors on one hand and the debtor on the other hand, were dual-pillared theories. And that dual-pillared theories were based on a prior philosophy of individualism, which she disagreed with. For her, insolvency law is a multi-pronged situation that involves the debtor, the creditor, and the community. And so it is a multi-pillared situation. Of course, she agrees with the other theories that insolvency law deals with cooperation when a debtor has failed and is owing multiple people. But what she makes, or what she offers as her main normative position, is that in insolvency law, society determines how to treat those who have failed financially in a credit-based economy, and what price, if any, it wishes to exact for those failures. For her, the interest of the community as an independent stakeholder was to be recognized in insolvency law and taken care of by the judge. Now, the paper Okay, so the paper details my critique of these theories, and when it becomes widely available, people can read it. But what I want to emphasize here is that all these dominant theories of insolvency law that I have discussed, all accept that insolvency law responds to a situation of multiple defaults involving several stakeholders. It is therefore a social situation that involves cooperation. Now, cooperation has been studied extensively in philosophy, and it is said to be required in situations where collective action produces better results than individual pursuit. Now, philosophers like Rawls argue that although social cooperation seeks to achieve mutual advantage for those who are involved, it is marked by two key elements. One is shared interest. These parties have interests in common, but it is also marked by conflict. Each person is interested in what the outcomes would be, and they are not agreed on what those outcomes would be. Now, this tension raises the question of fairness first, not efficiency. And a similar observation has been made by Rees-Mogg. While Rees and I are clearly in agreement that justice is required in situations of cooperation, my distinct argument is that the case for justice in insolvency law is even stronger. To be clear, fairness in a social context refers to justice. So when we're talking about fairness, and sometimes you hear us use fairness or justice, where effectively we're using them interchangeably. Now, although social cooperation seeks to achieve mutual advantage, it arises only where background conditions obtain. And these background conditions comprise 1, objective conditions, and 2, subjective conditions. So what are these? The objective conditions that make cooperation possible and necessary include proximity. This talks about the actual situation that brings the parties in close connection with one another. Vulnerability. That is the vulnerability of each party's interest in relation to the interests of the group. and moderate scarcity that makes it is moderate scarcity that makes it feasible to achieve mutual advantage through collaboration, but it is also understood in those situations that the output cannot satisfy all needs, and that's why the conflict arises. Now, they are also characterized by subjective conditions. So the parties have different but complementary interests that enable them to cooperate, but each has a different purpose that they want to achieve. Now, what Rawls argues is that these conditions are conditions of, or are circumstances of justice. Insolvency is a paradigm case of circumstances of justice, because both the objective and the subjective conditions are present, and the paper outlines them clearly. So very quickly, the debtor's failure brings the parties in proximity. Each individual's needs are vulnerable vis-a-vis the group. And of course, it's a situation of moderate scarcity because there isn't enough to go around. The parties have shared interests which enable them to cooperate. However, each has a different purpose, which also brings with it this conflict. Now, it is because the circumstances of insolvency are circumstances of justice that justice is the founding and organizing principle of any framework that engages with its resolution. Now, such a framework must be characterized always by social cooperation governed by just principles. And if you would just remember that, I will keep returning to that phrase. Now, this holds whether this framework that responds is a formal framework or is an informal framework. However, the type of framework that is set in motion determines the applicable test, and I will return to this as well shortly. Now, this is not a claim about what ends, what goals insolvency law should pursue. It is about the type of situation that insolvency is. Therefore, it is a matter of constitutive necessity, not a matter of normative aspiration. Or as philosophers would say, it's an ontological argument, not a teleological one. What insolvency law is, rather than what insolvency law should do. On this foundation, I argue, therefore, that all theories of insolvency law must confront justice directly. Here's the thing. They all do. We just haven't recognized it yet. But again, I will return to that in due course. So, on my own, I start by proposing what it is that my understanding of how insolvency law should be described. So I propose the justice-driven insolvency law, which I refer to, for short as JUDIL. Now, again, the paper sets out JUDIL in detail, but I will point out a few elements here. So my JUDIL is grounded in Rawls's substantive principles of justice, which comprise, as everyone will know, equal basic liberties and the difference principle with fair equality of opportunity. Now, what the difference principle does is that it guarantees each person an equal right to the full adequate scheme of basic liberties, which is compatible with a similar scheme. So everyone has the same rights as everyone, essentially, is what it is saying. This ensures that each individual involved, is treated as a free and equal moral agent whose basic rights and freedoms cannot be compromised for the sake of social or economic advantage. The difference principle requires that social and economic inequalities are to be arranged in such a way that any inequalities are justified only when they improve the position of the least advantaged compared to an equal distribution. Now, undergirding these two substantive principles of justice is the obligation of reciprocity, which Rawls says is also important. Now, what that means is that any form of cooperation must be undergirded by an obligation that requires all those who are involved in the cooperation and who play their part in generating the benefit in generating the value to benefit in an appropriate way. Now, recall that I said previously that the circumstances of insolvency can engage both formal and informal frameworks. While both frameworks must involve cooperation, because that is what circumstances of justice are, the difference lies in the test that applies, the test of legitimacy that applies. You see, the standard for the informal framework is different from the standard of the formal framework. The standard of the informal framework is based on the Rawlsian test. So it says that any terms or procedures are legitimate where the terms are freely acceptable to the justificatory constituency. Now, the standard for formal insolvency law differs because it involves coercion. Therefore, I apply the Scanlon standard here. And I say that terms or procedures are legitimate when they cannot be reasonably rejected by the justificatory constituency. So, what Judiel argues essentially that insolvency law is just where its term meets the Rawlsian principles of justice, are undergirded by an obligation of reciprocity, and cannot be reasonably rejected by its justificatory constituency. Now, I've repeated justificatory constituency a fair few times now, and some people might wonder, what on earth is this justificatory constituency? So, essentially, while I argue that the stakeholders, that is, when we talk about stakeholders to the non-initiated into insolvency law, those with an interest, so you would have your different types of creditor groups, because like the loss distribution, theory says, there might be broader interests, so interests of employees, interests of directors. All of these are people with an interest, they're people with a stake. So when I use stakeholders, I mean these broader ones. Of course, communitarian theory will tell you that the community is a stakeholder as well. So I'm going to address, where I fall here. Now, while I argue that the stakeholders whose interests are to be considered extend beyond merely the contractual creditors that the creditors bargain theory argues for, I reject the reification, that's the transformation of the community into a stakeholder group as the communitarian theory adopts or attempts or does. But again, I'm not unique. Riz does the same. However, I believe that public interests matter. And for this, I draw on my favorite ever philosopher who has influenced me the most. He's influenced my thinking, he's influenced my career, he's influenced my conduct. He's called John Dewey. And you would see that I tend towards pragmatism. And he's one of the fathers of pragmatism. And, Alet has tried to move me along T.H. Green for several years. And I said, well, no, I don't want T.H. Green, but John Dewey was also influenced by T.H. Green. So, I've ended up agreeing with many of the people who have taught me, I think, over the years. Now, the paper sets out the argument in full. But for now, I simply state that the terms that we agree, or the procedure that we agree, must also be considered legitimate by those who are indirectly but significantly affected. You see, the key stakeholders that we have been discussing, excluding the community, are those that are directly and significantly affected. I don't agree that we should include the community there, but those who are indirectly but significantly affected are the people that John Dewey describes as the public. Now, we don't have to treat them as a standalone stakeholder group. Dewey argues that you cannot, it actually does not make sense to argue that the community can stand alone apart from the citizens, that the community is embedded within the citizens. What is important is that the community is, it encapsulates the interests of the citizens. And that within any system, there are different publics. Some people are part of girl groups here, some people are part of boy groups here, some people are part of non-binary groups here. At the same time, they are students. At the same time, they are members of a family. At the same time, they are members of various types of associations. All of these are different publics because these are groups that have different interests. So at the same time, in any society, there are different publics. Now, what happens and what I expect to happen and what Dewey says should happen is that it is the role of the policymaker, when he sat in the room, to consider the interests of the publics where insolvency law is being made. And it is at that level that we consider the public interest. So, to operationalize all of these elements that I've been discussing, well, I created what I describe as Judill's evaluative framework that comprises a bipartite framework that has two interdependent components. There is an applicative element that secures justice within the operation of specific mechanisms, that is at case level. And then there is the systemic element, which secures justice in the design and public perception of the overall framework. These two tests operate at distinct but interdependent levels. So, for example, a procedure may satisfy the systemic test because stakeholders accept it as a fair framework, but it can still fail the applicative test in particular applications because individual stakeholders object to the treatment that they receive. Conversely, even careful application cannot remedy an illegitimate procedure. So let's see how this would operate. I've been one to keep within 40 minutes and I'm beginning to push. But a lot of this is described in the paper, and I do give a couple of examples in the paper. But because it's more a theoretical paper, you don't have too many examples. But what I would say here is that the applicative level enables parties, their representatives, and judges to assess whether a particular case respects the requirements of procedural and substantive fairness and the obligation of reciprocity. So there are four elements that will be considered at that case level. The first is procedural fairness. Did the parties have meaningful participation? Were the parties able to engage as free and equal participants in the process? If they can't, chances are they're going to challenge at that level. The next element is substantive fairness. This requires that inequalities must be to the greatest benefit of the least advantaged and that no party is systematically denied economic participation. This is where we have arguments about fairness, at case level. Now, all of these two elements are undergirded always by the obligation of reciprocity, which requires that all those who benefit, because remember, insolvency law, the formal insolvency law, is the realm of coerced cooperation. So it requires that all those who benefit from the coerced restraint of others must provide corresponding acquiescence. Now, the test that would apply at this level will be whether the allocation of benefits and burdens are such that they cannot be reasonably rejected by those that lose out. That is the Scanlonian test, and remember that is the test that I said applies at the formal insolvency level. And I tested this against my travel group PLC, and note that it can explain cases like Riadla, but it was these are very short explanations because I would like to discuss this, independently, fully, dealing with several parts of that in a different paper. Now, at the systemic level, Judill evaluates whether insolvency procedures as a whole, so administration, the company voluntary arrangement, restructuring plans, whatever they are are just and legitimate for resolving a debtor's insolvency. And it comprises two elements. One is scope and the other is acceptability. Now, scope is the level where we map all of the interests that are significantly affected by the procedure, and we understand their various, their varied interests. Like I've said, employees are unsecured creditors. They also have interest in employment, so they have various interests that must be understood. Now, it is not only those who are directly affected that will be discussed at this scope level. Those who are indirectly but significantly affected, that is where the publics and the public interest come into it as well. And the question we would ask at the acceptability level is whether the procedure as a whole is one that significantly affected persons cannot reasonably reject. Also, whether it is a procedure that the public can accept as fair. And this is where my interest in pre-packs, comes alive. Because with pre-packs, the challenge that it had was not simply at the applicative level, where certain groups were excluded procedurally, but it was also at the systemic level, which generated disquiet. And this disquiet did not stop until certain policy decisions were made. Therefore, the level of the systemic level is the level that I expect the policymaker to take into consideration, while the applicative level is the level that judges can apply, can deal with. You do not bring the community interest or the public interest to the judge to handle. It is a matter that will be handled at the policy level. Now, we have examined due deal and its application in full. And the paper then moves to its final question. What justice propositions, if any, undergird other insolvency theories? And I will try to, Just checking. Are you guys still with me?
Yes.
Okay, that's good to hear. All right. So, in this part, I'm going to focus on the creditor's bargain theory. The paper talks about how I deal with the other two theories, but the CBT is important to deal with here. Now, although much of the creditor's bargain theory's original vocabulary has faded, so things like the Roche and Veil, the debt collection claim, the liquidation focus, these are not really talked about as much anymore. But its core normative architecture endures. And so in contemporary insolvency scholarship, most CBT scholars are situated within the proceduralist approach to insolvency law. Now, this approach presents itself as pragmatic, as value neutral, requiring insolvency law only to facilitate creditor bargaining. Its canonical commitment to pre-insolvency entitlement, the preservation of pre-insolvency entitlements, the rejection of new rights, the rejection of redistribution in insolvency, continue to define this approach nonetheless. Now, wealth maximization would immediately emerge, or at least appear to emerge as the foundational conception of justice that applies in this to this approach. Now, wealth maximization is not only the expressed normative goal of, collective and compulsory bankruptcy rules. In fact, some iterations of the creditor's bargain theory refer to it as the creditor wealth maximization, theory. And we also know that wealth maximization underpins the economic analysis of law, which is the main methodology used within the proceduralist group. And since the proceduralists are proceduralists, they are only interested in that type of methodology. Yet, their uncompromising insistence on the inviolability of pre-insolvency rights and the strict adherence to the bargaining process more accurately reflect a distinct normative commitment that is most clearly developed by Nozick. Nozick's procedural conception of justice also reinforces the proceduralists' self-identification as proceduralists. Procedural theory for procedural insolvency law. Now, what then does Nozick argue, and how do I think that these two map onto each other? You see, Nozick argues that social structures, such as a state, so he was discussing state, the emergence of states, that social structures such as the state may emerge legitimately to provide a protective purpose. Its purpose is only protective. It preserves stakeholders from harm, that's the members, from harm to their person and to their property. He argues that a minimalist structure is the most extensive social structure that can be justified. So, that structure has no new rights of its own. It creates no special rights by virtue of its existence. It's regardless of any moral aspirations, it cannot redistribute holdings in order to achieve what he describes as patterned ends. So he cannot redistribute property or whatever holdings are in order to achieve equality or equity or, because it's a good moral end to achieve. Because to do that would be to interfere with the legitimate interests and the legitimate entitlements of those who already have them. He says that holdings do not come unattached. For you to take, you must take from someone who has a legitimate interest and give it to somebody else. Why should the state be allowed to do that? The paper unpacks his theory in more detail. But what we are interested in here is how the creditor's bargain theory maps onto Nozick's entitlement theory. Now you see, whether or not the proponents of the creditor's bargain theory or the proceduralists, today, drew consciously from Nozick, their normative exposition of the nature and the limits of bankruptcy law is best understood through this theory. Now, people tend to assume that Nozick expects individuals to act alone, but that's not true. A Nozickian frame expects cooperation governed by just principles as a response to the circumstances of justice. Now, the social structure we're discussing in this situation is insolvency law. Now, insolvency law responds to the circumstances of the debtor's failure. Without insolvency law, the interests of all stakeholders would be harmed by the failure to cooperate. So the dispute is not whether we're dealing with social cooperation, it is what we accept as fair terms of cooperation. And this is where we see the full play of Nozickian thinking in creditor's bargain theory. So, like Nozick, the proceduralists argue that insolvency law does not create any new rights. Like Nozick, they argue that it preserves and respects pre-bankruptcy entitlements. Like Nozick, they argue that the claims that they advance are a matter of right. In philosophy, that is called deontological arguments. Nozick's theory is a deontological theory. Wealth maximization is an instrumentalist theory. There is a key difference between the two. So, for proceduralists, any redistribution to achieve patterned ends, such as greater equality, greater equity, the ability to better absorb losses, unlawfully interferes with legitimate rights and should not be accepted. Now, I would go on, but I'm, looking at the time, 15 minutes. So I'll try to, so that we can have questions, I'll try to wrap up here. Now, my argument really is that the proceduralists' claims are not axiomatic principles of insolvency law. They are not value-neutral principles. They are not even efficiency arguments. What they are normative claims that reflect the entitlement conception of justice applied to insolvency law. So, it appears then that we all agree that we're dealing with circumstances of justice. We all agree that this must entail cooperation. We all agree that cooperation must be governed by just principles. Where we disagree is what qualifies as just. Now, it means that the arguments in insolvency that we have been having have not been arguments of efficiency versus fairness. They have been arguments about what type of justice we accept as serving the best interests of insolvency law. So I'll just skip on to the end, for the Q&A. I believe that, or what I argue anyway, is that Judicial advances an ontological basis, of a being basis for the legitimacy of insolvency law. And it demonstrates, therefore, why justice is the inexorable foundation of insolvency law. Given that circumstances of insolvency are circumstances of justice, it engages immediately social cooperation governed by just principles. And on that note, I think I commend Judicial to the field, and I thank you all for attending the lecture and for listening.
Thank you very much indeed for that fascinating lecture. I had the privilege of seeing your draft paper in advance, and I can truly say you brought the subject to life tonight in a really engaging way, so thank you. It is, I think, helpful for those of us who are studying the nuts and bolts of insolvency, teaching it, practicing it, or making decisions in it, to step back sometimes and think about these much wider, broader underlying issues like justice. But if I make a comment, to which will give rise to a question. The comment is, justice is inherently a subjective concept. If we think of the history of UK insolvency law, it's not that long ago. The just result to the non-payment of the debt was to throw the debtor in prison until they paid, which they couldn't, so until they died. Now, that was abolished quite a long time ago, 150 years ago or so, perhaps longer now. But the idea that we were a creditor-friendly jurisdiction remained. And if I truncate the 170 years of history since the 1830s to today, there's not much happened, I think, for the first century. But in 1986, we saw a move towards becoming more debtor-friendly with administration, with CVAs. We've always had schemes of arrangement, but they weren't much used for debt reorganisation in the 19th century. With the 20th century, we saw the Enterprise Act, and we saw the rescue culture coming more to the fore, secured creditors being their right of veto over administration being removed. And we've seen the European regulation on pre-insolvency measures, and we've seen the restructuring plan, which is, again, an attempt to try and prevent insolvency and enable debtors to avoid the consequences of insolvency. And that is a move towards a debtor-friendly approach, but also to try and either let the debtor survive, notwithstanding an insolvency, or to maximise the value within an insolvency. And taking it right up to date, we've seen in the most recent cases that have reached the courts over the restructuring plan, I think one can see that similar move towards preserving value for all in the debate that we've had as to whether the outcome and the relevant alternative of an immediate liquidation should be the only reference point for who shares in the value that can be created or preserved by restructuring. So it's a fascinating change from let's kill the debtor to let's try and preserve value for all. The question is this: when we think about justice, to what extent should we be driven, or should the justice approach be driven by or assisted by economic factors? For example, the broader question of whether we should approach insolvency by reference to what's best for the economic growth of the country as a whole, or market efficiency. To what extent do those wider concepts feed into, if at all, how we define justice?
Well, thank you very much for that fascinating question. Now, I would say that, in the 1970s, we had the London approach as well. And as I explained in my talk, the response to the circumstances of justice, because it was circumstances of insolvency, rather, that led to the London approach. And that was, again, we saw cooperation based on just principles being the response, because that's the only response you can get to circumstances of insolvency. Now, to what extent should justice respond to economic circumstances, or should economic circumstances drive, perhaps, the interpretation of justice? Well, this all depends on how we see what is going on and how we deal with the various interests that are concerned here. So, as I said, understanding Dewey tells us that individuals engage in associated actions. Those associated actions have effects. They have direct effects on some people and indirect effects on others, and sometimes these effects can be significant. So, the question is, to what extent do we take into consideration the interests of those who are directly and or indirectly affected by the actions of others? This immediately tells us that justice is not only about the economics, but also the social, because it is a relational issue. Now, to go to the policy question that I was, explaining, if we were to focus only on economics and to say we're discussing wealth maximization, for example, we also have to consider who participates in the maximization of the wealth and how that participation is done. Because if we constrain some people and coerce their participation in order to generate this wealth, but only a minuscule group of people or a subset of this group enjoy the wealth that has been maximized, it means that we use some people as instruments of the maximization of the wealth of a different group. Now, that offends a person who takes a view that human beings are free and equal. But it's not only a question of subjective offense. It is that, as we have seen with insolvency systems and insolvency procedures, it starts to send a message. And that message is quite likely to corrode the entire system as a whole, and that affects confidence. And once you destroy confidence of those directly engaged and the public in a system, you find that it is not used as it should be, and the economic achievements that you might be hoping towards might not easily be achieved. So if we picked the US creditor on creditor violence that is going on, for example, that has been talked about quite a lot. Now, the issue is that they are faced with circumstances of justice, but some strong and well-placed creditors have taken to individualized responses to the circumstances of insolvency, replacing the cooperation that circumstances of insolvency should normally respond to. The effects is that even proceduralists now talk about creditor-on-creditor violence. This is language of justice. It sends a wrong message about the system, and it is well written in scholarship that is emerging that it is to the detriment of the group. And that goes back to some of the initial arguments, or elements that I set in place, that when you have circumstances of insolvency, you are dealing with circumstances of justice. Those circumstances involve, moderate scarcity, vulnerability, and proximity. The response will always be social cooperation, and it must be, it must be just, it must be social. So, fixating only on the economics cannot resolve the issue. They are broader values.
Thank you, yes. Right, anybody from the audience would like to ask a question?
Did I bore everyone?
I think Brit has come up.
I had the pleasure of reading a previous iteration of the paper, which I enjoyed and learned a lot from. So I'm delighted that I learned even more listening to did you say it was the 6th iteration? Thank you. I really love the way that you incorporate, in particular, the Dewey notion of the publics. And that has a lot of relevance, including for Lord Justice Zacaroli's decision in the Thames Water restructuring, which we will leave to another day. I want to understand better how you set up your equation of the circumstances of insolvency with the circumstances of justice. And you put it in a number of different ways in the talk, which I did not pick up in the iteration of the paper that I read, so I'm just going to focus on the talk. Yeah. It is one thing to say that if everybody who is affected by an insolvency, everybody needs to cooperate, if that condition is met, that the circumstances of justice come into play. And I thought this is what you were saying, that insolvency is a situation where there are multiple defaults, and in those circumstances, everybody who's affected needs to cooperate. And if that is how you set up the equation, then I have the following worry. Certain stakeholders don't need insolvency law. Thank you very much. Take the example of secured creditors who are maximally able ex ante to structure their dealings through taking security, through pricing and other terms, through possibilities of exit from the debtor in ways which are not available, for example, to employees because they need to earn their living by continuing to be employed. So I think that if you put it like that, there is a question as to whether you can vindicate your claim, which I find very powerful, that the circumstances of insolvency are the circumstances of justice. I think that falls into the trap set by the proceduralists. I think that you have to be normative from the very start, and you have to say, it matters not whether some stakeholders can, while others cannot, do very well, thank you, without cooperating. It is a normative requirement that there be cooperation of a particular type on particular terms. What do you think?
So we're arguing ontology versus normativity. Well, for me, I mean, if you say, well, I fall into the trap that is set up by the proceduralists, well, the question is, why would secured creditors also participate in this? There are benefits to secured creditors to participating in the cooperation that takes place. I think that you would have to explain what you mean by fall into the proceduralist trap first, because Jackson argues this quite clearly as to the reasons why secured creditors, the administrative benefits, for example, would be one key reason why secured creditors will agree or acquiesce to this. And if the secured creditors, and that's why there's a policy level of this as well, towards the creation of the system that is in place. If the secured creditors are not being damaged and they enjoy administrative benefits, there is no reason why they would not acquiesce to or accept this cooperation. Therefore, I do not see how the normative undermines or the ontological, or why it should be the first step. I think that however it is that we look at it, the fact is that the situation of, or the circumstance of insolvency is simply a circumstance of justice. All the parties are vulnerable, looking at the group, and there is no other. We've seen different systems of secured creditors, keeping out of the system, but it is to the collective detriment, and it really is also then, there's an element of it, of course, that is normative, but initially, it is an ontological issue, and I don't see how we resile away from it.
Anybody else? does just... Oh, sorry, yes, Paul.
I'm not really sure I have a question.
I'll take a comment.
So it's difficult from my position, being actually responsible for the legal framework, because when I'm listening to you, and I've not read your paper, I didn't even know there was a first version.
I thought I'd spare you.
I'm trying to work out what it is that the current system doesn't do that you think it should do when listening to your model.
Yeah.
Because from where I sit, it's working all right, actually. And if you're proposing something quite different, I'm thinking, really? And how do you expect me to convince Parliament that what you're proposing will actually be a better way? Because when you talk about justice for all of those affected, I think at the moment the system that we have is one based rather on realism. Secured creditors are powerful. That will never go away. And those that are not powerful, other elements such as the state steps in and deals with the mess where it can. But where it can't, that's just an unfortunate aspect that that's what insolvency is. So I'm not actually sure I'm coming to a question other than to say, really? Really? What do you want us to do?
Yeah. I'll take your question. I think that it's not...
Because that, in a way, I have a similar supplement to that, is you talk about the public, and to my mind, there needs to be some externality for that. If the public is something else and not direct stakeholders, how is that managed? I'm basically a corporate lawyer, and I think there's a definite need for more externality in corporate law, particularly when private companies operate in public spaces. And I think that's a big loss. But I wonder how you manage the externality in the context of your fantastic paper.
Well, thank you very much, both of you. But I think that you're actually putting my paper into practice for me, because you're asking exactly the right questions. These are the questions that we discuss at the system level. So, Paul, if I can be, slightly cheeky, I can ask you, whether or not, following Sarah's paper, we should reconsider the, financial arrangement exceptions under the company moratorium, for example, and what the effect that has on, it is definitely a matter on the table, because if the way that the system is structured, the procedure is structured, for example, is geared towards the small companies, owing less than 10 million, but where the money usually goes is excluded from the system that is in place, that is a policy question that we should have. You see, due deal does not operate only at the applicative level. It operates also at the system level. And what it invites the Pauls to do is to sit and to take into consideration these effects. We're asking other creditors, other unsecured creditors and some other secured creditors, we're coercing their constraint. And the collective benefit is not being distributed across board, because some subgroups are excluded from having to make the acquiescence that may be necessary. It's a policy question, and it is one that Judeo invites you to consider. And there is also the applicative level, like I said, which is the level that the judges answer, and this is at, a stakeholder group, that feels that they've been squeezed out of the benefit can go to the court and say that, it's either we were not procedurally allowed to engage, the 4 components of the applicative level, or there was some substantive unfairness there, or that the obligation of reciprocity was not held. Now, it is not that those parties have to agree. It is that they cannot reasonably reject, and it is the job of the of the court then to see whether they are, reasonably rejecting or unreasonably rejecting. So there are 2 levels of it. And to answer Aled, Aled has tried to make a socialist of me for many years. For many years. Now, again, I think that the question that you're asking, sometimes it's about the way that particular procedures work, which is why Judil proposes, again, that systemic level. Remember that I talked about scope. The first level of that is the scope. Let's scope out the various direct and indirectly or significantly affected groups. Let's take out what their interests are. And then we will consider whether a reconfiguration of the system is necessary to ensure that it is one that cannot be reasonably rejected, particularly because insolvency law coerces. That is the level at which I think the interests of the publics, the various publics, will be engaged. It is not that those publics, like the Thames Water issue, come before the court and expect the court to treat them as an independent stakeholder. I don't think that that is the role of the court. That is the role of policy.
Very good. I noticed the time. We've overstrayed a little bit, but I think drinks are available now. So I think we should put our hands together again and thank